Thursdays are the day that this guy joins us, and this guy is the great David Katz. How about it for him, everyone? Cam, are you going to bring him in, or am I going to, what's happening on this show? I've got the guy, David Katz. I introduce him, and it takes a minute for him to come on. I don't like it.
Great to be with you.
Why are you yelling?
I am sorry, David. I am brimming with anticipation. We are going to be discussing something that I feel I was touching on yesterday is one of the preeminent agenda items of this Supreme Court, and that is undermining government regulation. Government regulation when it comes to the environment, when it comes to food safety, when it comes to consumer rights. This court, I think, is super corporate polluter friendly. And I'm wondering if you can speak to the case that they are hearing this week. This involves, it's being called the fisherman case because it does involve fishing and overfishing and government monitors. Maybe you can give us a sense of what it is and how the justices seem to be leaning.
Well, they say that although it's called the fisherman's case, it was a half an hour into a 3-hour argument before the word fish was ever spoken. Because what it really has to do with is Chevron deference. It has to do with how much deference the courts are going to give to expert agencies. Now, you have to bear in mind, Mark, for things like environmental regulation, the agencies are full of scientists. They're really experts. They have a lot of experience with this terrain. If you allow the courts to just decide it at first blush, you're going to have all these different judges. And so this is a huge agenda item for the right wing, especially for these people like the Koch brothers, who want to have less regulation by the EPA. Stock market operators want to have less regulation by the Securities and Exchange Commission. And all of these regulatory agencies, what they do and how much deference to give to their expert judgments was what was on the block today. The irony is that the particular case has to do with fishermen, and I think the reason that the Koch brothers, the people who don't want regulation, particularly of the environment and of energy and of things like that, I think the reason that they picked this case as a test case is because it's kind of sympathetic. What actually happened in this case was that Congress said they needed to take steps, and they passed a law to ban overfishing. And they regulated it in various ways. The thing that Congress was silent about was if you were going to have monitors on fishing boats as a way to make sure they didn't overfish, who was going to pay for it? Congress didn't mention that. So the expert agency in charge of fisheries said you have to take on your fishing boat a regulator, and you have to pay that regulator $700 a day. So just at first blush, if you're just looking at it, you could say, oh my goodness, they made the people who were regulated take the regulator with them and pay $700. Now, the Biden administration saw this challenge coming because these are appeals, Mark, from 2 different federal circuit courts. So they were brimming. They were coming to the surface in the courts, in the federal courts. The Biden administration saw which way it was going, saw that this was being used as a test case to batter regulators throughout. And so they actually they got rid of this rule, or they got rid of it to the extent that they actually paid the $700. So they paid the people who had to pay the $700, the fishing boat operators, they paid them back their $700. And they're going to argue, I think, that it's really moot under those circumstances. It's not a case, it's a case where certiorari was granted, but what they say improvidently, or it's become moot because of the facts on the ground. And Chief Justice Roberts actually asked, how important is this Chevron deference? But it's really disingenuous because, Mark, it happens in situation after situation in the lower courts, decisions after lower court decisions, that Congress just hasn't spoken expressly to the issue. Think about AI. Think about if Congress passes a huge bill to regulate AI. Is Congress going to think about everything that's going to happen in a week or a year from now or a decade from now? No, they aren't. They're going to have an expert regulatory agency that knows all about AI, and they're going to make these calls where it's ambiguous, where it's not exactly clear what Congress intended. How do you decide in a particular case whether to apply the rule of the agency or not? Do you defer to the expertise of the agency, or do you allow the case to be shopped around like they've shopped around this abortion pill case, like they've shopped around a lot of these other cases? Can you shop that case to any district court judge in the country? And can you question the agency's use of their discretion? And obviously, the huge polluters, the people who hate regulation, who bristle at regulation, even though they make billions of dollars in our economy, they're the ones who want to have this change so that they can run the case to some district judge and they can say, well, the courts are the ones who ought to interpret it. But the reality is these expert agencies are often the ones best equipped. As Justice Kagan asked today, sometimes judges need to know what they don't know. And some district judge sitting in Amarillo, loose cannon, as we lovingly call her, down there near Mar-a-Lago, to bring this case of environmental disasters before her, to bring cases that are incredibly important in terms of their impact on the environment, on how we live our lives, on the state of the planet, all that kind of stuff, the stock markets, to just shop that case around to some district judge. Now, people will say, well, you can take it from the district judge to the appellate court, and you can ultimately take it to the U.S. Supreme Court. But our system has worked very well. We do have, I don't want to be Pollyanna, but we have effective environmental regulation. And people who don't think it's effective, it would be a whole lot less effective if we ever get rid of Chevron deference.
So well said. And I would say, David, even if you say, well, to those people who say, well, it's going to go up to the appellate court and even the Supreme Court, none of those justices in any of those courts have the expertise that you will find when it comes to science and chemistry that you'll find at the EPA when it comes to evaluating toxins and toxic dumping and the number of pollutants and parts per billion that can exist in air, soil, and water. I mean, I see this as a massively effective way to undermine government and regulation. And, you know, we're talking about the FDA, the USDA, as you say, our food. I mean, it's not just corporate polluters. It's all the different protections that we find ourselves, I think, in a way, these are protections that are set up in these government agencies that have taken time to build. I'm sure we're overregulated in some ways, but this idea somehow that every regulation is a regulation, it's a protection. And I'm very concerned with them all going away. How do you... Yeah, go ahead. Sorry.
You mentioned the FDA, the the Food and Drug Administration. Think about this one, and I think that this was one of the questions from the three moderate to liberal justices today. They said, okay, how do you decide whether something is a drug or a dietary supplement? You need a lot of chemistry. You need a lot of analysis. You need an agency like the Food and Drug Administration that has had these kinds of questions come before it hundreds, indeed thousands of times. To go bring this case before a district judge, and they would try their hardest. I'm not impugning any of our district judges, but they would try their hardest. They would have experts. But the reality is that issue ought to be presented to the agencies. And if the agency gets it wrong, you could take it to the appeals court. If you have fact finding in the FDA, if the EPA holds a hearing, remember we had this in an earlier case, how much of a hearing does the SEC have to give you, right? Does the SEC have to go through the courts, or can the SEC give you a hearing? And these agencies have independent arbitrators. Now, some people will poo-poo that if you want to think that there's a deep state and they're all in it together. But no, there's a part of the IRS that enforces, and there's a part of the IRS, which is the tax court, okay, or the Department of Justice, which is the tax court. You could say none of them are the courts. None of them are the Article III federal courts, okay? But there is a judicial system. There's an administrative judicial system within these agencies, within the SEC, within the FDA. So you can have a hearing, you can bring on your experts, and there's an agency that has the expertise. And if you don't like the ruling, you can go up to the federal appellate courts, including if the U.S. Supreme Court takes it, you can take it to the U.S. Supreme Court. But at the end of the day, these agencies have expertise. The system works. By the way, I don't think that they are going to get rid of Chevron deference. It seemed from the long argument today that there are 5 votes that are going to keep Chevron deference to some extent. And maybe
so let's just be pure about what that means. That means that the existing regulatory agencies would survive then that judgment.
They would survive, and still in the case where the statute is ambiguous. Those are the people who say Congress should deal with it. Congress dealt with it as best Congress dealt with it. They passed the statute that they passed. And in many, many instances, like what's a drug, what's a dietary supplement, what's an effective environmental protection of wetlands, what's going too far. all those kinds of ambiguous questions, like the fisherman one itself, will be decided by the agency. You take that one, for instance, when Congress says we're going to protect against overfishing and we're going to have inspection of it. And if they just spelled out, that means the operators have to pay for the regulator who goes on their fishing boat. That would be the end of it. If they said it shall not be imposed that the fishing boat operators have to pay for it, that would be the law. They didn't say either way. And so some agency figures out, you know what, the best way to enforce this thing is to have one. They could have had three. Maybe that would have been unreasonable. But to have one, and to have that one paid the $700 by the guy who's got the commercial fishing boat, who's going out to fish thousands and thousands of dollars worth of fish, that person should pay $700. They said that was within the agency expertise to enforce that law because Congress had been ambiguous. And Amy Coney Barrett asked a very good question today, which makes me think that she may be the fifth vote to keep Chevron deference, to keep what I think is the sensible rule of deferring to the agencies in these questions where Congress has been ambiguous or not clear in the statute, to defer to the agency expertise, as long as it's reasonable. And the way that you do that, where the statute's unclear, defer to the agency deference if it's reasonable. She said, if we go the other way, if we get rid of Chevron deference, and the lawyer for the People Against Regulation said, end it, don't mend it. End it, don't mend it. But I think the worst that's going to happen is they're going to mend it, because Amy Coney Barrett said, if you get rid of this, there'll be a flood of litigation. Every single regulated person with money will go back and say, wait a second, you deferred to the agency, you shouldn't have. You, district court judge, should decide this, ab initio from the beginning. I want to show all of my evidence that the $700 was unfairly imposed. I want to show that it was it was this, it was that, it was the other thing, the environmental regulations. They will attack that with all of their money, with all of their great lawyers. They will go back and attack every one of those agency determinations. That Amy Coney Barrett, who's a fifth vote, I think, to save Chevron deference, she got it. But you're absolutely right that this is a harbinger of getting rid of regulatory regulations, whatever you want to call them. People can say we're overregulated. We're also protected. Thank goodness.
Exactly.
We're protected in so many of these ways. We don't have terrible drugs on the market. We don't have an environment in even worse shape than it would be without Chevron deference. As you say, this is a key issue, but it's hard for people kind of to get it because it seems like inside baseball, administrative law. You thought administrative law was boring. Not if this case goes the wrong way.
Yeah, this is another point you're making, which is that this is a critical case. It's really a way that the U.S. government could change. That is to say, we could be governed increasingly by the courts. Already, I feel that's happening. But the idea somehow that these regulatory agencies that have these protections in place, these are protections for our air, our soil, our water, that are already tepid, in my view. They're not strong enough. They could completely go away, or it could surrender to the courts. You'd have essentially all of these regulatory powers being surrendered to the courts. It's a huge issue, but the point you make at the end here that I really like is that it's not getting a lot of attention. It's just not easy to understand as a horse race between, Donald Trump and Nikki Haley and Joe Biden, and here's how they're polling. And I mean, that's easy to understand. And the winter weather and Gaza, and these are all important things. But there's something going on right now, and it's not involving sleight of hand. It's right out there at the Supreme Court level, but it's getting underreported in media.
This will be decided by June, like everything else. The Solicitor General argued on behalf of the United States that this would truly be a shock to so many of our systems and how we live our lives. And Kavanaugh said, I guess to be clever, he said, well, it's a shock the way it is right now, where every 4 years it seems like the personnel at these top of these agencies change. But to me, there's nothing wrong with that. That's the politics that ebbs and flows. And yes, you can have someone who's the head of the EPA under Trump is not going to be the same person that Biden would pick to head the EPA. If Nikki Haley wins, she'll pick a head of the FDA who won't be the same head of the FDA right now. These agency heads who've lasted a long time, like Fauci, it's wonderful. But normally the very top person, all of these agencies, changes, and the policies can change. But it's not nearly as radical, that change, that shock to the system, as if you can shop a case around to a particular district court judge. And you know what's going to happen? The people who don't like regulation, they're going to bring it in the Fifth Circuit. They have certain kind of judges they're going to bring it to. They bring all of these cases to a particular judge down in San Diego, these gun regulation cases. And it's so much better. We don't have they never let the ATF be the kind of agency that, controls firearms like we have the FDA and the SEC, in part because the gun lobby is so strong. But these agencies that we do have existing, the FDA, the EPA, the Federal Trade Commission, the SEC, you can name many more of them. It's so easy to knock them and say they're big bureaucracies and so forth. But, thank goodness that we have them. So you don't have every stock isn't a swindle. Every drug isn't dangerous, right? Everything with the environment, the polluters are always winning, or they're just overwhelming any opponent of environmental regulation. Thank goodness we have those agencies. I'll be the first to stand up for them and say, I know that some people think we're overregulated, but we're protected by these agencies. People just really need to bear that in mind, and how important this decision is. And of course, how important your vote is for president, because the two of the justices, I think, are really not I think they might actually cut back Chevron deference. But I think Chief Justice Roberts, and from her questioning today, Amy Coney Barrett, will at the worst mend it. They won't end Chevron deference, and it's good to have that deference, I think, to the agencies. That's my policy view.
I mean, I think it's indisputably the case. So I'd love to hear you say it. I mean, as we've noted on this show and all along the way, these agencies, many of which you've mentioned, are already victims of a regulatory capture that we've seen play out with Boeing. Just as we've begun to X-ray and scrutinize Boeing a little bit more, you see that the FAA has really kind of let them run amok. Same thing you could say is happening on the FDA side. I think you can argue that with the Pfizers of the world, this kind of thing. I think you can argue it back and forth. I know some people at the FDA who would push back on that. But all of that said, these are agencies with a highly skilled expertise involved with the various people who are in most of the positions there. And so I agree with you. I think this is a titanic decision coming, and series of decisions along along this route to getting rid of big government and overregulation, or however they term it. I want to ask you, now I want to visit Trump with you, and then I want you to help solve an argument that Kim and I are actually having. It's it involves a very serious case, but I'm sure everyone's going to have an opinion on it. Donald Trump is, he's again on this E. Jean Carroll case because he talks smack about her, he defames her, and now he's in court having defamed her again, and the question is going to be, I guess, how much he is going to pay. You can set me straight on this, but he's been a really rude and uncooperative participant in this judge's courtroom. Today, he was apparently producing enough looks and, sort of physical movements and verbal reactions to the testimony as it came in from E. Jean Carroll that the judge threatened to remove Trump from the federal courtroom. This is according to multiple people who were there in the courtroom, loudly saying things. He said, he called the judge a nasty guy, used terms like con job and a witch hunt. And the judge essentially said, hey, this is a quote, Mr. Trump, I hope I don't have to consider excluding you from the trial. I understand you are probably very eager for me to do that. And Trump said, I would love it. And then he said, I know you would. That was the judge who said that. You just can't control yourself in this circumstance, apparently. And Trump said, you can't either. The reality is Trump can't control himself and the court can't control Trump. Isn't that the reality?
Well, I know people need a scorecard, but, Trump is facing 2 federal criminal trials. It looks like one may still be on track to go in March, the D.C. one involving the insurrection and so forth. The one in Mar-a-Lago, the other federal trial, looks like there's no way it's going to go to trial before the November election. There's also 2 there's 2 state criminal cases. One of them is the one down in Georgia where a lot's happening. In addition to those 4, and there's the New York case by the DA, which is a criminal case. That's the one that involves Michael Cohen and Stormy Daniels and covering up paying hush money to her. With all those foregoing, there's also a civil trial that has been covered quite a bit. That's the one over the fact that he overstated his assets when it came to trying to get bank loans, and he understated the same assets when it came to paying taxes. That's the one that just went to closing argument. In addition to those 5 cases, there's E. Jean Carroll against Trump. That case has gone to trial already. She won, he lost. Okay. Another one of Trump the loser in court. And then after Trump the loser lost in court, then he defamed her again. So now that's going to go to trial. But in the interim of that, while he was president, okay, he also said she was a liar, she's not my type. He said all this derogatory stuff while he was president. That case kicked around, Mark, to find out whether he had any immunity for that while he was president. As we saw in the Bill Clinton case with him being sued, it turned out he had no immunity from civil suits. So guess what? This is how much damages there is, because he lost the first trial with E. Jean Carroll, and she showed that he had sexually assaulted her when he said that she was a liar about sexually assaulting her. By the same token that the jury found that he had sexually assaulted her, he defamed her when he said that she was lying because he had indeed sexually assaulted her. So that issue in this second trial with E. Jean Carroll has been decided. This is another one which is all about damages. This is how much money he has to pay. And he's decided that it will help him not have to pay that much to come to court, which he has a right to do because it's a court case and you have a right to attend your own trial, civil or criminal. But what you can't do is do exactly what he's doing, Mark. You cannot make faces at the jury. You can't say these things sotto voce, which you really are stage whispers that you want the jury to hear. That is utterly, totally improper. And all of us trial lawyers, we admonish our clients, don't do that. Don't make faces. Don't say things in stage whispers. And Trump is violating the advice that no doubt he got from his lawyers, because he actually wants to, in this case, be thrown out of the courtroom, because all of his base will know about it. They'll never follow it in the New York Times or on your show or in their local newspaper if it's covered, okay, or radio, TV. They'll only follow the fact that Trump will say, you see, the deep state judge threw me out of the courtroom. I can't get a fair trial. Look how I'm getting thrown out. So Judge Kaplan is smart. He knows that. And Kaplan is trying to figure out. So yes, he has a duty to maintain the decorum of the courtroom, but also he's smart enough not to play into Trump's hands. And obviously he's thinking about how does he maintain decorum? How does he show people that there is a rule of law, that no one is above the law, that you cannot act really with contempt toward the court like Trump is doing, but he's trying to figure out. So what he's done now is I think he's warned him. And I think by now, with the record that he's made, if he keeps doing that, he'll, in his stentorian voice, which will not be covered live or the camera, because there's no camera in the federal courtroom, but he will say, here's the record. You did this, you did that. That was improper. I warned you. Okay, you cannot act, with contempt toward this court. No one in America can. You're not above the law. He'll give a great speech, which will be on the front of the New York Times if he goes back. And Trump just may say, you know what? I did what I did. The jury gets the fact that I'm very unhappy, and Trump may not even come back again. He's always playing what he thinks is going to work out best with his base for how he's going to play this supposed victimization. No one's victimizing him. He all he had to do. He didn't have to defame.
He didn't even have to show up. Actually, he doesn't have to be in the courtroom.
Right now, he's paying the price, and he may not even show up for the next day. And I think the jury will come back with a big damages award. Mark, don't you?
Yeah, that's really what's being talked about, and it's just so funny that I think you stated so well that the judge has to strike the balance of sort of allowing this kid to disrupt the class, if you will, enough to not let him grandstand and cut him out at the first peep. But if he keeps chirping along as he is, and if he keeps violating the rules of the court, then you toss him. But it's a really tough balance that judge has to strike. So not the easiest spot. Now I want to ask you about a case that will be coming. A teen arrested after leading a group assault on a student in Santa Rosa. Santa Rosa is about an hour north of San Francisco. This is in a high school. And Kim and I were actually speaking about this. So, Kim, maybe you want to come in and you can share maybe a couple of the facts if you're able to. It was a group assault on a 14-year-old girl in a restroom.
Yeah, high school bathroom, Montgomery High School. One of the girls arrested is 14 years old, and allegedly she had pushed this girl to the floor of the bathroom, ripped out chunks of her hair, and then punched her in the face 30 times or more. The girl, the 14-year-old girl that was allegedly involved in this, has been arrested at her home in Santa Rosa. And right away when I was telling Mark about this case, because I have a 14-year-old daughter, and it's shocking to me that this could happen in a girl's bathroom in the county where I live. And he said that type of violent assault, the girl needs to be charged as an adult. And I said, but what about her, her brain? They're still mushy. They're not fully baked yet until what? They're 25. So you're going to take a 14-year-old girl and treat her like an adult and throw it away.
I said it, as a society, it's baked enough apparently for her to perpetrate that kind of violence. So, but you're the jurist here. Tell us the truth here as to the way you see it.
Well, I think most people believe in a juvenile system of justice, that you don't generally treat people who are 14 as adults because their brains are developing. You're so foremost in your mind is to rehabilitate them and to have them have a different life and not be in the criminal justice system and not have a record for the rest of their life. Then you have some egregious cases. You have people who are 17. We had one down here. It's one of the issues they're going to try to use against our district attorney, Gascon. There was someone who was 17 and like 10 months. It was a really grisly murder. And he treated the person as a juvenile because I think he'd run on that he believed in the juvenile justice system and he wasn't going to treat people under 18. He wasn't going to, put them over in adult court, which is something that the DA has a lot of discretion about. And he ran on, he was not going to exercise his discretion. And a lot of people said, you know what, that's different. You exercise your discretion. That 17-year-old person who was a month short of 18, you should have treated him as an adult. And, for one summer, I was a Brooklyn district attorney for the summer. That was my summer intern job. And at that time in Brooklyn, we had hitmen. We had 15 and 16-year-old hitmen because the cartels, the gangsters would give that assignment of hitting somebody to a 16-year-old because they knew the worst that was going to happen was they'd go to juvenile court and they'd be out of the juvenile justice system, even if caught. And of course, there was huge pressure to not treat them as juveniles. I mean, with that narrative. So I guess my feeling about this is it's terrible. And hopefully nothing like that will ever happen to your daughter or anybody else's, or anybody else's relative. But at the same time, from what I'm hearing about that, I don't know, if I were the district attorney in your area, 14, I'd probably have her go to juvenile court. I probably wouldn't treat her as an adult. If that girl had died or suffered like scarring for the rest of her life and I had discretion, I might think differently about it. And then, of course, you get pressure from the parents. In Gascon's case down here in LA, there was a lot of pressure from the family. They went to the media. I'm sure that when the election goes with Gascon, we're going to hear from that family. We're going to hear about that case. So I hope I answered it somewhat.
Yeah, you did. I mean, I think that you and Kim are sort of like-minded on this. I think I've seen our society evolve in dangerous ways, and one of the dangerous ways is that violence has perpetrated this culture in many more ways and many more age groups than I would like to accept. And I think I'm with you. It's like, oh my God, it's a 14-year-old, and a 14-year-old can change. And I'm not saying a 14-year-old can't change, but I think that maybe it's not full adult court, but I think juvenile court isn't sufficient for a crime of violence. When you talk about a crime of violence that passes a certain threshold, and again, this is my opinion. You're such a legal scholar. I really yield to what your thoughts are, but I still think you can maybe rehabilitate this person. But I do believe that there is a level of violence baked into the DNA. It's not literally the DNA. I mean, I think it's through a lot of things that happened in that child's upbringing that lead them to this. So my heart breaks for the perpetrator, but my heart breaks more for the victim. I guess that's where I am on it.
Mark, there are juvenile detention centers. So it's not like this 14-year-old, because she's in the juvenile system, is going to go home. She may be in a juvenile detention center for a long time. I had a client that I was able to help. He was about 17 years old, and I called him the Einstein of the barrio. He was like this fantastic kid. He's in the service now. He's doing a great job, serving his country. I got him out of this problem that he was in, but he had to spend, before I got him out of the problem that he was in, he had to spend a couple of months in a detention center, which we did in the summer, because he didn't want to mess with his 4.0 grade point average. He really was a brilliant kid, in my opinion, wrongly accused. Like I said, I got him out of the trouble that he was in, and he's doing in the Army now, doing a great job. So I guess what I'm trying to say is that there is detention, and there were some people in there that, from my client's account of it, they were getting rehabilitated, but they were pretty scary when you heard of the stuff that they'd done, but they weren't home. They were in a detention center. So in terms of protecting society from people who are very young, but are very vicious and very prone to recidivism, there are juvenile detention centers, and people are not home and out in the neighborhood.
As a follow-up, David, what happened to the 15 and 16-year-olds in that Brooklyn case that you were talking about? That several, not one singular case, but in the case of those Brooklyn kids.
Well, I was only there for the summer, but at the time, at least under the law then, there was discretion to treat them as an adult. The judge had to concur that that was a proper thing to do. But if you get treated as an adult, you can get a life sentence. And then, there's some reforms of that. There's a lot of people who come along and say, wait a second, if you were 16 when you committed the crime, even though you got an adult sentence and you got life, you ought to be eligible for parole. They ought to, if you really are rehabilitated. And then a lot of people think, there's all these different opinions about parole. Some people think everybody gets parole if you do something awful, awful, awful. You remember the Manson family people. And no matter how much they showed they were rehabilitated, it was like, you're one of the Manson family members. You shouldn't you should never be out on the street again. So there's some view of that. And then there's another view that, the parole system is too unyielding, and that they ought to give the person a break. And even if he was a 16-year-old hitman, now he's taken courses, he's rehabilitated, he's a totally different place in life. He's 30 years old. Why not release him? And, they'll go back and forth. 30, you should be released, even if you were a 15-year-old hitman, proven to a court, right, beyond a reasonable doubt. And some people think, oh my God, you murdered 5 people for the cartel, and you're getting out at 30. So that's our criminal justice system debate. Yeah. You can have that in any bar and every salon in America, right?
Well, the chat lighting up with opinions, so we'll share some of those, but it was definitely Kim and myself going back and forth on it. I just felt it was such a brutal crime of violence, but maybe I'm reacting emotionally to that crime of violence as well. David, love spending time with you. Thank you so much. We're going to watch this SCOTUS situation, the Trump situation as well, and we'll check in with you next week.
Great to be with you guys.
Love it. David Katz, everybody. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.